What rights do you have under Canadian law to defend yourself or another person? Over the next 2 episodes of Don't Talk TV, I'm going to give you an in-depth analysis of Canada's self-defense law. Hello, my name's Nicholas Wansputter. I'm a criminal defense lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. In Canada, you do have the right to self-defense and you have the right to defend other individuals. This is governed by Section 34 of the Criminal Code of Canada, and I think it's very important for Canadians to understand what their rights are under this legislation and to understand how it works and see that, in fact, Canada has quite reasonable self-defense laws. Unfortunately, given events of the last year and the economic impacts that are coming, crime may well increase in Canada, and people may need to know what their rights are when confronted with violent individuals. So in today's episode, I'm going to go through the law as written in the statutes and explain it as we go. And then in the next episode, I want to go through some specific examples of how courts have interpreted this law and how they've applied it. Self-defense law in Canada is governed by Section 34 of the Criminal Code. I've got it up here on the Government of Canada's Justice Laws website. So Section 34 indicates that a person is not guilty of an offense if they believe on reasonable grounds that force is being used against them or another person. So that's the belief component. Secondly, that the act that constitutes the offense is committed for the purpose of defending or protecting themselves or another person. So that's the intent or purpose component. And then the third is that the act committed must be reasonable in the circumstances. So in terms of the belief component, belief that you're on reasonable grounds that force is being used is the state of mind of the individual. Does that person believe that they're being attacked? Now, it's a subjective belief. Does that person in their own mind believe that they're being attacked? But it must also be based on reasonable grounds. The Reasonableness Assessment allows the trier of fact to reflect community values and normative expectations in the assignment of criminal responsibility. When the law uses an objective component, it does so to ensure that the acts or beliefs it accepts are reasonable ones. It is a quality control measure used to maintain a standard of conduct that is acceptable not to the subject but to society at large. Reasonableness isn't judged from the perspective of the hypothetically neutral reasonable man, divorced from the accused person's circumstances. It's contextualized by reference to the accused person's personal characteristics and experiences to the extent that those characteristics or experiences were relevant to their belief or actions. So, for example, if an accused person had had some violent encounters with their attacker before, their knowledge of that person's violent background has to be taken into account in assessing whether the actions they took are reasonable. Now, not all characteristics or experiences are considered relevant, however. For example, an accused's quote-unquote honest belief that all young black men are armed and dangerous could not be taken into account in one case when determining the reasonableness of their belief, because that belief is just that all young black people carry firearms is just not reasonable. It's very broad stereotype. I don't know if it's even a stereotype. It's just a very broad generalization that doesn't have any bearing in reality. The next section, Subsection B, deals with the motive that the individual has for taking the act that they did. So they have to first believe that they're under attack, but then you look at why did they take the action that they did. Now, this is purely subjective without any reference to whether it was reasonable or not at this stage. And this is pretty straightforward. It's simply, was the action taken for the purpose of self-defense or defense of another individual versus was it out of vengeance or out of anger? And you can't camouflage revenge as self-defense. It has to legitimately be in the mind of the person who's defending themselves that they think they're doing this to defend themselves. Then the third section is the reasonableness of the action that's taken. And this has objective and subjective considerations, as with the belief that one is being attacked. And it can include mistaken beliefs, as long as those mistaken beliefs are reasonable. So if one mistakenly believes that they're under attack, there has to be something to back that up. So say someone was lunging at them, it would be reasonable to think that you're under attack, even if that person was in fact just joking around. Then Section 34 sub 2 of the Criminal Code gives a list of factors which is to be considered in assessing whether the action taken was reasonable. So for example, the nature of the force of threat is considered. So whether it was a push, whether it was someone was pulling a gun on you, someone was pulling a knife, whether they'd invaded your home, whether that person was running away. It also looks at the extent to which the force was imminent and whether there were other means available. So versus a threat that might occur down the road, it may not be reasonable to punch someone if they said they're going to come get you next week. Subsection C of this looks at the accused person's role in the incident. So whether the person claiming self-defense did anything to contribute to the situation, whether they were the instigator perhaps, or whether they did something that caused the situation to become violent, whereas it may not have otherwise been violent. It's to be considered whether anyone in the incident, either the attacker or the defender, was armed. And certainly it's a different situation if the attacker's armed, the defender isn't, or if only the defender's armed and the attacker isn't, and the defender is now introducing a weapon. The subsection E says that the size, age, gender, and physical capabilities of the parties to the incident is considered. So whether one individual is much bigger or much stronger than the other individual, that can influence whether it's legitimate self-defense or not. The nature, duration, and history of any relationship between the parties, including any prior use of threat of force. So if you have a history with someone and know them to be violent, that is going to inform whether your belief that they're going to attack you is a reasonable one. And in look again, subsection C, the nature and proportionality of the person's response to the use of force or threat of force. So if someone throws a punch at you, it may not be reasonable to pull a knife out and stab them to death. Or if someone is starting to retreat, if you continue to chase them down, or if you knock someone unconscious and they're no threat to you at all, you cannot continue to attack them and consider that self-defense. And then finally, there's a consideration under H of whether the act committed was in response to a use of force that the person knew was lawful. So if you know that you're being lawfully detained by a police officer, you don't have the right to defend yourself against that. This video is not legal advice. As always, contact myself or another lawyer. My 1-855 number is below so that we can provide you with tailored advice to your particular situation. In the following episode, I'll be looking at some specific cases and how courts have dealt with self-defense law, which I think will help give a greater understanding of what exactly your rights are. As for today's episode, I've covered the statutes that govern self-defense law. If you found this video informative or helpful, please consider liking and subscribing.